What happens when a small gas station operator signs a lease he doesn't understand, and that lease says he must pay for injuries caused by the oil company's own negligence? In Weaver versus American Oil Comazon, the Indiana Supreme Court tackled the fairness of exculpatory and indemnity clauses buried in fine print. Welcome to 99 Rights Online, where we turn courtroom chaos into clarity, and we break down the law fast, fiery, and meme-worthy, so you can know your rights before someone reads them to you. In 1972, American Oil Company presented a printed lease to Howard Weaver, a filling station operator, which included a hold harmless clause requiring Weaver to indemnify the company for its negligence. Now, Weaver had limited education, no legal expertise, and signed without reading or understanding the terms. An American Oil employee negligently sprayed gasoline on Weaver and his assistant, causing injuries. But in court, American Oil sought a declaratory judgment to enforce the indemnity clause against Weaver, who refused to assume liability for the company's negligence. So the court had a question to answer: whether the hold harmless and indemnity provisions in the lease are enforceable against Weaver, given the disparity in bargaining power and Weaver's lack of understanding of the clause. So here is the rule. A contract or clause may be unconscionable if 1. If one party takes unfair advantage of another's necessities or lack of understanding. 2. If it is a burden on the party presenting a printed form contract to show the other party new, unusual, or onerous terms. 3. And if it has any exculpatory indemnity clauses that are enforceable only if entered into knowingly and willingly. The lease was presented on a strict take it or leave it basis. Weaver, a modest gas station operator, never read or understood the lease terms, and American Oil never explained the indemnity clause or suggested he seek legal counsel. It was buried in fine print with no title to flag its importance. The clause was almost impossible for Weaver to grasp, yet it imposed a crushing burden. Weaver, earning a modest income, would be forced to indemnify American Oil, even for the company's own negligence. The Indiana Supreme Court reversed the trial court judgment and stepped in. It ruled the clause unconscionable and contrary to public policy. But why? Because there was no real or voluntary meeting of the minds. Weaver had no meaningful choice while American Oil used its superior bargaining power to shield itself unfairly. So why does this case still matter? For law students, this case is a landmark case on unconscionability and adhesion contracts. For citizens, the bottom line here: when contracts are one-sided, hidden in fine print, and exploit vulnerable parties, the law calls them what they are: unconscionable. If you want more landmark cases explained in plain language with powerful visuals, subscribe to 99 Rights Online. Share this video with friends, because knowing how courts protect against unconscionable contracts can safeguard your rights in everyday deals. Thanks for watching. This was 99 Rights Online, where law gets loud, clear, and viral. Subscribe for justice that hits different. If this breakdown made the law feel a little less intimidating and a lot more powerful, don't scroll away just yet. Like, subscribe, and share to keep your rights sharp and your feet spicy. Because justice isn't just for lawyers, it's for everyone.